Good morning, everybody. Thank you for being here. I would like to call this meeting to order now that it's 10 o'clock. This will be our roll call in establishing a quorum.
Ms. Feld?
Here.
Dr. Sullivan?
Here.
Dr. Bradbury?
Here.
Dr. Lazarchuk? Dr. Lazarchuk? Dr. Lazarchuk, I think you're muted. Maybe he stepped away. I'm going to go ahead and mark him as absent right now. Once he joins us, I'll make note of when he joins. Ms. Laredo?
Here.
Dr. Sequoia?
Here.
Ms. Esri?
Here.
We have a quorum.
Thank you. So our next agenda item will be public comment on items not on the agenda. Seeing none in the room, can we please open the online public comments?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment for items not on the agenda, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. Okay, then moving on, our next item will be number 4, our update, discussion, and potential recommendations from our equine practice subcommittee, which is I'm sorry. I skipped over number 3. Apologize. So our review and approval of the October 18th, 2022 committee meeting minutes, please. Anybody have any questions or comments on the minutes?
Under guests present, Nicole Dickerson from the CVMA is an RVT, not a DVM.
So on page 1, Nicole Dickerson should be listed as an RVT. Sorry, it's on page 2. We have note of that. Any other comments, corrections, concerns?
I move to approve as amended.
I second. Sequoia seconds.
Thank you. So we have a motion and a second. Any further comments from the board? Okay, seeing none, any comments from any members of the public present? Okay, then if we can please moderator, open the online comments for public comments on this item.
This is the moderator, and at the direction of the board, or the committee, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. It looks like it appears that I am getting requests that WebEx is not allowing individuals to raise hands. Give me one moment.
Moderator, while you're doing that, for the record, I'm going to mark Dr. Lazarchuk present.
Thank you. All right. It looks like I had clicked off the wrong setting. Barbara Schmitz, if you'd like to check to see if the raise hand is working now. All right. Okay, and it looks like Barbara has a request for comment. And Barbara, you'll be given 3 minutes to speak in a 15-second warning. Please click the unmute me button when the prompt appears on your device.
I'm assuming that you can hear me, but perhaps not see me. I appreciate the opportunity to comment. I do have some concerns about one of the agenda items and want to share some feedback. I'm here on behalf of the San Francisco SPCA. Again, my name is Barbara Schmitz. Our organization is 155 years old.
Ma'am, I apologize for interrupting. Right now, this is public comment for the meeting minutes themselves. So if you have public comment regarding the meeting minutes, we could take that now. If you have public comment regarding an item that's on the agenda, then we will have public comment after each agenda item to where you would give your public comment to that item.
Okay, thank you.
All right, this is the moderator. It appears there are no further requests for public comment on this item. Would you like me to close that Q&A panel?
Yes, please. Okay, so we have our motion in a second. Can we please call a vote?
Mr. Phelps?
Yes.
Dr. Sullivan?
Yes.
Dr. Bradbury?
Yes.
Dr. Lazarev?
Yes.
Ms. Laredo?
Yes.
Dr. Sequoia?
Yes.
Ms. Usry?
Yes.
Motion carries.
Thank you. Okay, now we can move on to agenda item number 4, which is our update discussion and recommendations for potential recommendations for equine practice subcommittees. So Dr. Sullivan and Marie.
Okay,
I'm just wondering, I'm sorry, I was struggling with getting my internet on, so I apologize if I've gotten mixed up here, but I think that individual wanted to make a comment on public comments and maybe couldn't, or she wants to actually comment on an agenda item.
Yeah, she said she had a concern about something on the agenda.
Okay.
And so we're going to wait to that item.
Okay, just want to make sure she had her chance. Thanks.
Okay, I am going to discuss item A, and Marie is going to take care of 4B. So some of the issues raised by stakeholders involve the veterinary client-patient relationship and veterinary examination requirements as applied to equine practice. In addition, stakeholders raised concerns that the Veterinary Medicine Practice Act and supporting regulations did not define herd and failed to properly resolve issues regarding animal owner, client, and animal trainer for purposes of establishing the VCPR. The subcommittee reviewed the regulations and determined the VCPR regulations should be moved to statute, which would provide the most direct and timely manner to address these issues. The subcommittee drafted a legislative proposal to place the VCPR requirements along with a few other issues into statute. The subcommittee then met with CVMA to discuss the legislative proposal, and CVMA agreed placing the VCPR in statute rather than merely revising existing regulations was the appropriate action. The legislative proposal is not intended to expand the scope of practice, but adds important terms and definitions and organizes the VCPR and its requirements in one location. Due to the amendment of the same statute, the legislative proposal discussed herein includes the telemedicine legislative proposal previously adopted by the board at its July 22nd, 23rd, 2021 meeting. As attached in this memo, it would, and I'm going to go through each of these items, those that pertain to board action that has already occurred, we'll go over, but it'll be just cursory because that discussion has already taken place. So starting on page 5 of your memorandum, starting on page 5, you'll see that we have added the definition of client, an appropriate place to put it. And I better find some glasses or I'm in trouble. And client simply client means the owner of the animal. Pretty straightforward. Number 2, we add the definition of the word herd. We've been struggling with a definition for herd for years, and we have found that it's necessary to address that. This may take some discussion. So herd refers to any group of animals of the same species and location at the same geographic location. So I think we need to open that up for just some discussion by the committee.
Okay, so Dr. Sullivan's asked for any discussion for the committee on the definitions that have been presented from page 5 of their report.
This is Dr. Sequoia. Can you hear me?
Yes.
Okay. Let me go back to that. So looking at the text for herd and then looking down, excuse me, at livestock, are you considering combining the two to say that herd only applies to livestock, or are you going to leave herd as refers to any group of animals of the same species and located at the same geographic location? Because obviously that could be a kennel or cattery. So this
Exactly.
is
We wanted, the intent was to include, and you'll see as we move further, it is specifically to address prophylactic treatment of vaccines and worming and herd procedures, husbandry procedures. So we did want to include kennels, catteries, stables, any place that there's a group of animals that may need a treatment that would not require individual VCPR for every procedure.
Thank you for that clarification. I have just one little more question on that. Are you going to define group as to numbers, or is it anything over 1?
We did not define group. Again, this will be defined later as to what procedures can be done with a herd.
But that doesn't really answer the question of how large your group is before it becomes a herd.
If you're doing the procedures that are going to be outlined, I would say you could have a group of 1.
Do you want to put that in writing or not?
I don't, but that's open to discussion.
I'm just asking. I'm just trying to anticipate what people might be thinking when they read this. Thank you.
So Dr. Sullivan, I think for enforcement purposes, we would read group to be anything more than 1.
Okay.
My point is, I don't think enforcement would ever think of group as being a group of 1.
All right.
So I know a lot of work has gone into this and in a very rapid period of time. Thank you for all of that. Reading this, and I don't know whether it matters much or not, but that statement there, any vet hospital has a group of the same species in the same geographic location. So any vet hospital can use dog prophylactically deworm all the dogs in their hospital or any cats in their hospital. Do you know what I'm saying here? I don't know if maybe I am not seeing that clarified further down.
I don't think that we had considered that. I'm just trying to think. I think as it's used in the context of where we're applying that term, I think we're okay. But again, that's why we're discussing it today.
Yeah, I know what the intent is, and I doubt that anybody would, I don't think that there would be many people interpreting it that way, but it could be, I think, I don't know why anybody would interpret it that way and just do that, but it could be, if somebody got without consent from a client treating an animal and just saying, oh, well, it was part of the herd.
No, we're not suggesting there would be anything done without the consent of the owner in the term of a herd. Mm-hmm. So where it is used in the Practice Act, it is with the consent of the owner. What we're envisioning down the road is to further define in regs how this may work so that the medical records can be a group medical records rather than a medical record for every animal that's vaccinated in the herd. Mm-hmm. Let's say with a stable or a kennel or cattery or shelter.
I would add that Dr. Sullivan was referring to the other uses of the term herd, and that's on page 6 in 4826.01. And we're creating better clarification as to what it means to have recently seen or be personally acquainted with the care of the animal by either examining the animal or if the animal is a member of a herd. That's where we're using it. So we're trying to define how the veterinarian is knowledgeable about the status of the animal for purposes of examination to establish the VCPR, and then separately their herd medical records in regulation. So we're trying to clarify two different things, the examination and the medical record. Getting back to livestock, that definition right now excludes equines. That's just existing law. The term herd in this sense would include equines for these purposes for administering prophylactic care or treatments to multiple animals if the MDC thought that a definition of group to mean 2 or more animals, that might be acceptable, because otherwise the single animal can easily be examined, the point with a group is that you're not individually examining every animal to provide prophylactic care. You're just lining them up and providing vaccines quickly. And similarly, if you're creating a medical record for one animal, that's easy enough. We don't necessarily need the term herd for the medical record for one animal. We need it for a group of animals who are provided treatment, and we're trying to create an efficient way of documenting that treatment in some form of a client record. I hope that clarifies a little bit what the intent of defining herd means. It's for examination purposes and medical record keeping.
Do you think that we need to define it further in saying 2 or more animals?
I don't know that you need to, but you could.
I mean, if it's one animal, it's got to be in the medical record anyway.
Right.
I think it's a given. I mean, I don't think it needs to be defined, but from the legal standpoint.
If we're talking about the examination piece, and you're trying to avoid having to personally be acquainted with the animal, and not perform an examination of one animal, you potentially, I guess somebody could argue that one animal is a group. I think that argument would fail, but maybe to make it very clear to everyone, it could be herd refers to any group of 2 or more animals of the same species.
I see that Jennifer has her hand up for comment as well.
Yeah, thank you, Leah. I just wanted to comment. I realize we're just specifically discussing VCPR at this point, but some of us may recall that the term herd health was a point of contention when discussing shelter medicine. And from my perspective, a herd could be one. We may have specific protocols to treat a quote unquote herd of animals. And it's not so much individualized care. For example, if a dog came into an animal shelter with a potentially infectious disease, we might treat that differently in the interest of a herd for animals that may come in at another time. So I agree with Dr. Sullivan that a herd could be one animal. And I think that we need to consider that as we discuss whether or not to define the number involved with herd.
Any other comment? I can go either way with it.
This is Dr. Sequoia. I have a comment about Jennifer Laredo's comment about her example of an incoming dog to a shelter with a potentially infectious disease. Actually, I'm kind of looking at it, yes, it's a single animal, but it's in addition to the herd of the animals in the shelter, the dogs in the shelter. So it's an incoming addition to the herd. So I don't know. This is an interesting question. I don't know what I would say. From the simplistic viewpoint, I would say 2 or more, but this is a very interesting point that Jennifer brought up.
And that's why we haven't tackled this definition for the last 20 years. So,
right.
I guess I would defer to legal because I think that regardless, as it is stated, as what we're established as in the later sections here, I think that is what narrows how the VCPR can be established. I think the shelter issue is quite different in that that animal coming in that's potentially ill, the staff is following a protocol that's unrelated to prophylactic treatment. Well, I guess not. They're vaccinating. Yeah.
Dr. Sullivan, may I make one more comment about the shelter situation example that was proposed by Jennifer Laredo? My understanding is that, and from my past experience in working in shelters and volunteering at shelters, is that the incoming animal cannot be treated until ownership of that animal has been transferred to the shelter, which would make it part of the herd legally. Correct?
I'll defer to the staff on that.
No, the shelters do not own the animals.
Well, I'm sorry, they have responsibility for it. The previous owner has relinquished the animal to the shelter, and I'm sorry, I'm forgetting the correct term.
So oftentimes in shelters, the owners are unknown.
Frequently, correct.
Ownership doesn't transfer to the shelter.
Right, and the VCPR right now excludes animals who the owner is unknown. So you don't have to establish a VCPR with an unknown owner because you can't. You need an owner to be able to establish the VCPR. I would also note the shelter exemption from the Veterinary Medicine Practice Act in 4827. I think it's subdivision A5. It is not the practice of veterinary medicine to provide a list of care to animals lawfully deposited with or impounded by a shelter. This includes administering preventative or prophylactic non-prescription vaccinations to the animal pursuant to protocols. To the extent an animal needs prescription medication, we would want, this is really aimed at unregistered individuals, veterinary assistants providing this care, so it was a more efficient process for administering vaccines and flea treatment. If the animal needed prescription medication, we would need other statutes to come in to authorize those individuals, such as RBT registration and VACSP permitting to administer those drugs, because at that point they're dangerous drugs as defined under pharmacy law because they require a veterinary prescription for use. So I don't want to go too far down the rabbit hole on this. I think that if you are inclined to aim this at a group of animals, this was intended to be the ranch or farm situation, not thinking this was shelter because we've got these other shelter protections, and we also have shelter regulations that we're looking at. I mean, the MDC has been parsing these two issues out for years. Shelter is not a ranch situation. I think that you could continue to use herd, define it as a group of two or more animals, because if it's a singular animal, do we really need this efficiency? A veterinarian can examine one animal and treat it and document that treatment in one record. But when you're talking about a group of animals, that's the herd situation. We wanted to create something that was easier for veterinarians to provide the treatment the animals needed in an efficient way.
Okay, so I will go ahead and move that we amend this term to be a herd refers to a group of two or more animals of the same species and located at the same geographic location.
So just for efficiencies, maybe we just make that amendment and then we have one motion at the end to move that motion as
Sounds
amended.
Good.
I see Jennifer's hands up, I think, again. Yes.
It is, thank you. I just wanted to point out, great questions, great comments, but I'm looking forward to potentially other changes in the Practice Act, and I know we like to have consistency with terminology, so if we do further define herd, I want us to keep in mind that that will apply to any other regulations that we might include. But I can think of individual situations where you might have one cow on a ranch, that constitutes a herd for a number of reasons, but I just wanted to keep in mind that if we do further define herd, we should keep that terminology consistent throughout the Practice Act.
Thank you.
Dr. Bradbury?
I'm just wondering if we want to just keep it simple in statute, and then if we needed to address things later down the line in regulations, like we have more latitude there, and this way this is a more general term, and I think that's what you were thinking initially. Am I correct in that?
Well, not related to this. The problems with the regs is if this makes sense to us today, I think we should do it because regs are going to be 2-3 years down the road.
But I mean, like keeping it
yes, simple. As much as we can, yes.
Because the interpretation and all of that may change as time goes on, and if it's too prescriptive in statute, it's much more difficult to address than though it takes time in regulations. Like, I don't know. So I'm fine with either way, but I just was I think, Jennifer's point of like, if the more we define it here, the harder it is going to be for other,
Okay, but remember that when we are using heard related to what we're doing here, it is specific for prophylactic
yeah,
treatment and.
yeah, I'm fine with
okay.
that, yeah.
Okay, probably should get comment from the.
Okay.
Public.
Any public comment from those in the room? Bonnie?
And to clarify, right now, we're just taking public comment on the definitions portion of it.
Thank you.
There you go. Okay, thank you. Okay, you obviously put a lot of work into this. I think it's amazing, but of course, I have a couple of issues. My biggest issue, and not to open up another can of worms, is the definition of owner. I've been dealing with a lot of strict liability lawsuits lately, and ownership is an issue of an animal. And I also deal with VMV complaints where, for example, there's an adult child who actually, brought the pet home, and then the adult child goes away to college, and then who becomes the owner? And then at the end of the day, the father says, I want this animal euthanized, and the adult daughter comes home from college and says, I don't want it euthanized. And, it ends up being a nightmare as far as the VCPR and who the client is and who's calling the shots. So I know it sounds pretty simple to say that the client is the owner, but the problem is there's no definition in any state as to who owns an animal. What we use is we try to say, okay, well, if you have medical records on that animal or you have a registration under your name, then technically you're the owner. We use that when we do strict liability cases. But I think it's going to be a little harder than you think to just deal with the owner, especially when you're dealing with equines and potentially litters of puppies. And I don't know if you know Martina Greer, but she brought this issue up at an AVMLA meeting several years ago about, because she is a theriogenologist. And so I know that owner, I hate to open up another can of worms because you just dealt with herd, but I don't know if there's some way to more clearly define owner so that we aren't dealing with that at the end of the day with more of a nightmare. I think your idea about herd is really good. I still have a little bit of an issue, again, with the issue that Martina Greer brought up about theriogenologists who deal with litters of puppies all the time. And what if there's just one puppy? Is that just one puppy? I would think, yes, you have to examine that one puppy, but I think clarification would be great since I deal with clarification all the time. Thank you, and thanks for all your work on this.
Could I ask a question then? So this is in relation to the VCPR,
Yeah.
Which is then linked to the medical records. So at some point, somebody has to take ownership. And as we're using that term client, and then later on allowing the agent to speak for the client or the owner, how do you clarify it more than what it is?
I actually like client better than owner, only because I have recently gotten involved with these cases that are a mess with an adult daughter. It usually seems to be an adult daughter who says they own the pet, and then they're away at college or they're away someplace else, and then the father brings or you have a disagreement between two spouses, or they're getting divorced, and one of them gets the animal, and the other one says, well, it was my dog to begin with. I'm the one that needs to call the shots. So in a way, I like client better because I can more effectively argue that the person that signed, the person who put their name on that client information form, or the person who signed the authorization for that euthanasia or that medical procedure was the client, and therefore that's the person that we're dealing with. When you bring in owner, now it's open to, well, we're getting away from client, who's the person that signed the authorization, and now we're talking about the owner, who could be a completely different person. than the person who signed the authorization at the vet's office.
But aren't we being more specific here and saying the client is the owner, the person that signed that patient in as the client is the owner as regards to the medical records and the VCPR?
No, because you're actually defining the client as the owner, and the owner is the thing that we really can't put our finger on. So you're taking something that to me is the client, which is more easy for me to define because that's the person who signs that client information form or that authorization for care. That's the client, and you're defining it by using a term that's less specific rather than more specific. I think that's the issue that I have, because owner is a big deal. We deal with this in the strict liability statute all the time.
So we're concerned about establishing boundaries for licensees and trying to find ways to protect the consumers. So we needed to come up with a way to have an agent for what we've heard is bad scenarios on racetracks and situations where another individual, such as a horse trainer, is telling the veterinarian to perform specific treatments. So we're trying to address that larger issue, and we were really wrestling with, okay, well, what does a veterinarian, what does the licensee need to do to protect themselves? Because we don't want to create a bigger problem for them. So we didn't put any requirement that the agent authorization be in writing, because many times, especially in small animal clinics, it's oral, if at all. You've got emergency situations where you've got a neighbor or the pet sitter bringing the animal in. They don't have anything in writing authorizing them to be the agent for the owner. So I'm more interested in protecting the licensee who's just trying to comply with the law. The law says they have to have a relationship with the client. Who's the client? I'm thinking, if anything, perhaps we could consider creating a non-liability clause for the veterinarian who's relying on the representations of the individual bringing the animal for care. Would that help?
Well, in most veterinary hospitals, they're going to get authorization for emergency care, euthanasia, surgical procedures. So I count on that. I mean, that's what I look at. I mean, I look at who signed that authorization. That's the person. I don't care if you call them owner, client, neighbor, whatever you call them, but they're the person who's on the line that says, yes, euthanize this animal. And so that really is the issue, because vets do get those authorizations, and they do have client information forms that are filled out by the client. And sometimes you'll see, there's a daughter and a mother and father, and they're all named on the client information form. But at least you have that authorization. So the horse thing, I understand, is different. But I think the definition of owner is the same, because I think that the equine that's in the room would agree that horses are oftentimes owned by many people. So, saying that the client is the owner could also be very confusing as far as who is the owner of an equine.
Well, in that case, we could just add a paren S after owner. I mean, we're anticipating situations where there are multiple owners, but we're trying to call to attention the veterinarians need to ensure that whoever is requesting treatment needs to have a legal right to do so. It can't just be that somebody thinks that, this horse will perform better for the trainer if they get certain medication. The owner needs to be involved in these decisions or have delegated that authority to someone else.
Right, and I understand the horse, but I hate to see a new statute or regulation that will also apply to all my clients, where there's going to be a lot of confusion about the client is the owner, because owner has no legal meaning as far as a pet in California. It really doesn't have any legal meaning, and that's what we struggle with the strict liability statute, because, you know, what is an owner? I mean, who's the owner of a pet? Who knows? I mean, you know, you don't sign on the bottom line to be the owner of that pet. There's usually no records of that. So while I understand the issue with the equines, I'm concerned about my small animal clients and the effect that it's going to have on them by defining all clients as owners, because there will be people who will pick that up and say, okay, well, you aren't the person on the license, so therefore you're not the owner, you're not the client.
Right, that's what I'm saying. We could put in a provision that says the veterinarian shall not be liable for relying on ownership status reported by the individual who brings the animal in. You know, the veterinarian has to rely on something. They're doing an intake form, filling out names, you know, who's the animal owner, whatever. This is what we have on file. This person said they were the owner. We're going to rely on that. We're not trying to create a situation where veterinarians have to, you know, well, we need documentation that you have some kind of legal interest in this animal. I'm trying to, you know, get at your situation by, you know, cutting off this strict liability. This is just a VCPR, and we want the veterinarian to have a relationship with the client, diagnose and examine the animal patient, communicate what the diagnosis and treatment plan is so the client is involved. That's it. We're not trying to, you know, create additional problems for the veterinarian, but right now those problems exist in other contexts.
Right, but why not define the client the way you want to define it? Why not define the client as the person, somehow, as the person responsible for the care of the pet?
Can I just make a suggestion?
Some kind of,
I'm sorry, I've been trying to make, can we just say owner, parentheses, S, comma, or agent, designated agent of the owner, parentheses, S, and that would then be the client is the owner or owners, or the designated agent of the owner, owners. And that would then define client as either of those people. That would...
Well, it won't solve your problem with the equine because you're defining agent.
The designated agent is the trainer.
Is different. You're going to have two different kinds of agents.
I think we've defined that further down where it is the trainer and all of those, whatever we've defined it as, but something of that nature, I think, would basically solve the problem you're worried about.
As long as you don't have two different definitions of agent, but as long as you use agent to be whatever, then that would work for everything, as long as it's clear that the agent that you're talking about in small animal ends up being the trainer in equine, you know, however you define.
I think an agent, and I'd have to look at...
Agent is a legal term.
Yeah.
Agent's a legal term, and it would be it's more easily understood than owner.
So under, on page 6, under C, that's where agent's used again, and it says for purposes of paragraph 1 and 3 of subdivision A, the client may authorize an agent to act on the client's behalf. So there's not a formal definition of agent. That's just the only other place where we're authorizing the agent.
Grant?
Hi, Grant Miller, CVMA. So in building on Bonnie's suggestion, so one suggestion that Tara has is to create a liability disclaimer. That's one way. Another way might be to just change the definition of client. So right now you have a noun in place of a noun. What we need to do there is put action to describe what the client is. So it would be verbs instead. So the client is the person who identifies themselves, who identifies themselves as the decision maker for the animal or as the person seeking services for the animal. And then there may need to be a subsequent definition of agent, although I tend to agree with you that, and Bonnie, that agent is inherently defined. So if you know that they can act on 1 and 3, we should be fine. But instead of saying this noun is a noun, say this noun is doing the following things. So the client is the person who presents the animal to the veterinarian and identifies themselves as the one having the authority to make decisions for the animal's health care needs. And when I think about the components of the VCPR, they are the ones naming the veterinarian as the person, as the designating the veterinarian to provide care for the animal. That's when you think about the VCPR, it's I choose you, you choose me, I examine the animal, and we make a plan. So the client is the person choosing me. They're the ones coming in and saying, I would like your veterinary services. So if we could phrase that verbiage, it removes the owner problem. It takes the noun out of you're just swapping nouns when you're doing it. It just puts closer identification onto what is happening in the VCPR.
I think as far as the enforcement perspective from it, I get what you're saying. I think in what you stated, though, we're going to still have scenarios where the owner is filing a complaint of the equine saying the trainer provided these medications and I did not want the trainer to do any of that. So how do we protect the owner, the consumer?
Great question. Provided that we can phrase the statutory language in the correct way, I believe that that problem can be solved in regulations by creating a separate record-keeping requirement for those who are treating a herd. And that's, when you go back to the Wisconsin language that we provided, it has a trifurcated record-keeping structure, so that if you're looking at an individual small animal, the following data has to be collected. If you're looking at a herd, which they define as being livestock or food animal, you do this. So on those, they talk about what is the type of appointment that you're doing, my train of thought is straying because I'm trying to remember what the actual regulations say. But there's an opportunity in there to require the veterinarian to identify either the agent or the owner. There's an opportunity, I think, in the regs to be able to say, this is something that if you're going on to one of these horse farms and you don't necessarily have every single owner in front of you, what is your obligation as a veterinarian to determine that? And I think that's very reasonable. As an equine veterinarian myself, there are very few circumstances anymore in which I don't ask the trainer about, well, who is the owner, what was their desire, what do they want, what was their concern? And I view the agent to be more as a conduit of information rather than a decision maker. I think that if the agent were to be the decision maker, we would need to have some kind of documentation showing that they had that responsibility. So some kind of agreement between the trainer and the horse owner to say, I, as the trainer, have this carte blanche ability to make decisions for your horse if it's in my training program. And that might be something that we have to obtain by documentation in our records for those circumstances. So that wouldn't be statutory as much as it would be regulatory in those circumstances. Does that resonate? So that would be a record-keeping requirement if you're approaching a situation where you have a herd where this agent is acting on behalf of multiple different owners. Is there some kind of documentation that we can obtain to show that they have the ability to make decisions on behalf? Because if the trainer says, well, I don't have anything that allows me to do that, I have a responsibility then to go back to the person who does have that. So if they're just the agent and they don't have the ability to make those decisions, I have to find somebody who can make those decisions for the horse.
So then getting back to this definition, I guess my next question is, do we actually need it to be defined? I mean, we use client a lot in the VCPR, so does it need to be defined?
Do you have a?
Well, I would like it either to be defined by what the client does. I agree with Grant completely, or leave it at client. To me, client is a legal term that I feel comfortable defining, whereas, you know, an agent is a legal term. And I would also bring up that I have a lot of friends that show horses, dogs at very high level, and those dog handlers have extensive agreements that they carry around with them that allow them to seek, veterinary care. So, I mean, that's another area where the agent, could be used. But I do think defining it by what the client actually does rather than just saying the client is the owner, I think that's problematic. Or just leave it at client because, and again, if the owner complains, the board doesn't really know who the owner is either. I mean, when you get the complaint and it says, I'm Sally Jones, I'm the owner of Fluffy, you don't know whether it's the actual owner. You don't know how they determined that they were the owner. You're going to do the investigation anyway, just the same as you would. And then at the end of the day, there's not going to be this confusion about who actually authorized the procedures. Because it's really going to matter who authorized the procedure, not who made the complaint. That makes sense.
Yeah, Dr. Sullivan, I see what you're saying, though, because if we are just leaving it at client, then it doesn't need to be in this definition section, is what you're asking. Like, do we take it out if
legally client is defined elsewhere, then do we even need it here?
Yeah. Right, and this is just in the definitions page. Like, if we aren't going to write C client and then period, that wouldn't help for definitions. So that was the question, right, that you had, Dr. Sullivan?
Yeah.
Yeah. Well, I mean, legally, I'm comfortable with a client because I can look up all kinds of case law that talks about client and who the client is. It's a legal term. Owner is not really. So by defining client as owner, that leads to more problem than just having it be client, as far as I'm concerned.
Thank you.
Thank you.
Okay, for staff, do we need to define client here?
I don't know. I mean, these are the kinds of, really substantive changes that, really take some time to deliberate on. If you guys think that the current Practice Act with its use of client and the regulations is fine the way it is, and we don't need to further define it for situations that we were trying to resolve, that I think CVMA and CHRB and, others raised the issue of trainers authorizing treatment, who's the client. I mean, that removing client here, however we define it, I feel like brings us back to the same problem we were trying to resolve. I mean, we're trying to resolve something that was brought to us. If we take out any definition of client, we're back to where we were. So, I think it's possible to come up with a definition of client, which would be something like, presents the animal to the veterinarian for veterinary care and represents to have authority to make decisions for the animal's care. But we've got to be really careful. We should take our time to think this through properly. I don't want to start making changes on the fly and then throw it up to the board and then it just gets passed out. I want to be, cognizant and mindful of the changes that you're making because the term client, as soon as we define it, it's going to have a pretty big meaning.
And I want to make sure that the consumer is protected when the consumer says, I did not want the trainer to do those things, and they did it anyway.
Well, we have, sections throughout where we're using the term client, and it hasn't been defined up to this point. The decision then is, I think, one of two things: either define it as Tara has given, or to remove it. So, what is the committee's thought on that?
I don't think we should remove it based on the whole purpose of this. I think removing it, I understood why you were thinking that, but just listening to Jessica and Tara and thinking about, having the issue of people who have their, in this case it was horses, at a facility, and they felt like they didn't give the authorization that they felt they would have liked to have had,
But Tara's definition won't resolve that. Her definition of client is the person that brought the animal to the veterinarian. And in this case, it's not the owner.
That's right, but either you're present or you're designating somebody else to present the animal on your behalf. So, I mean, it could work. And be broad enough for small animal clinic purposes.
And then have the, add into regulations like Dr. Miller was suggesting, a requirement, which of course would be later, but to have some sort of written documentation of, I know you didn't want to put that in here, but some written documentation that.
Right, we don't want an extra document from the perceived client or perceived agent. Yeah. But
we could do that in.
The veterinarian on the backside could document in the medical record who is the agent authorizing the treatment on the client's behalf. But yeah, so for these purposes, just to establish the VCPR, which is the contractual relationship really between the veterinarian and the individual presenting the animal for care. I think we should come up with a definition for client. I think if we have the definition for client as the action of presenting, then the agency piece, that's part of the relationship. The client can delegate an agent. I think then that's fine. I think that still works.
But again, it's not addressing the equine stable issue at all.
Well, the owners are not at the stable. We know that. So that they could then delegate their agents.
Okay. So, do you have some verbiage for this then? Client means the individual that is bringing the animal or animals to. Grant.
So Grant Miller. So for consistency, if you just turn the page to page 6 to 4826.01A1, the client has authorized the veterinarian to assume responsibility for medical judgments regarding the health of the animal. That would probably be verbiage that you'd be looking for the action that defines the client.
So if we have it in statute here, do we need to define it under definition?
I think it would be nice. Dan, who, as you know, is another attorney, says that it could go either way, in his opinion. Either don't have anything there for client or define it as the action that they're doing. I don't think it would hurt to have it in a definition section. I always like terms to all be grouped in a definition section. It's very helpful to users of the Act to have that there. And Bonnie will probably fix me on that, but remember that also client is not necessarily one person. So if you say it is an individual who authorizes, there may be multiple people who authorize. So we might want to look at that just a little bit more to determine. So if I have a situation where I know that the horse is syndicate owned, I have horses, sorry for being graphic, I have horses that the horse's body is owned by one person and the sperm is owned by another person. So any sperm that comes out, that is now the possession and ownership and control of another individual. So it can get really complicated with some of these syndicate ownerships to try to figure out who I'm beholden to with various parts of the body. So I think that we do need to give a little bit of discussion to the term an individual who, because the client could be multiple people. So, but the action is clear. They're the ones that are, I would say, not only presenting, or not even necessarily presenting, authorizing, because an agent can be the one presenting, but they're authorizing the veterinarian to assume responsibility for medical judgments regarding the health of the animal.
It's not just authorizing the veterinarian to examine, diagnose, and treat. There's got to be more. If we strip out owner, then the client has to have you know, they're representing their authority over the animal in some manner. So it's, I think that's the piece we're missing here. Who is the client? They have some right or authority over the animal to be able to enter into this contract with the veterinarian. That's it. That's the piece,
Right.
you know, because otherwise, okay, well, the trainer then is the client,
Right.
and it's the same problem.
Yep, that's a good clarification, and that is correct.
I just wanted to add that I think definitions are great. So, I mean, if you're going to define it in one, because this happens all the time, if you're going to define it one place and you use it someplace else, define it there too, just so there isn't any confusion, because then it's clear in that particular statute, because you have subject matter experts that are reviewing these things, and sometimes they don't have a complete grasp of the whole Practice Act. And I have some new attorneys that I'm training who don't have a complete grasp. And so it's really great if the definition is included with anything new that you're doing, if you know that that definition is important, or at least refer back to where it's defined.
So, Tara, I'm sorry, Dr. Redden.
Okay. So maybe we write something, the client is an individual or individuals that has demonstrated the authority to make decisions regarding a patient or herd. I don't know.
I think demonstrating could be misconstrued and be difficult. Yeah, I think it's going to have to be that they're making some kind of representation to the veterinarian that they have authority over the animal's care.
Do we want to kind of maybe work on this in the next couple of hours and come back to it? I think it has to be addressed legally, and I'm not capable of doing that. So either we put a halt on this totally.
I would recommend moving forward to see if there are any other concerns with the rest of this proposal. And then, you know, as soon as, you know, once we identify the things that need tweaking, I think that, you know, depending upon how difficult it is to resolve the issues, we could, you know, put a pause on it and bring it back later. I just want to be really mindful that if you're passing anything out today, these are really substantive changes. I don't know that the board and the public will then have effective notice of, you know, significant changes. So I don't know that we need to rush this. It's possible that today we identify concerns, and then we come back in April after working with CVMA and maybe even.
Well, this is the legislative package, so if we don't resolve it, then we're looking at putting it off for another year. Okay. Well, do you want to move forward and see what else might be an issue? More stumbling blocks, then we don't have a choice. Okay, so we're going to put client on hold, and we're changing herd to 2 or more.
I think there's a motion for that, but I don't.
You know, so we're going to put that amendment in, and then once we take one motion, we'll take it all together.
Okay. So then, where are my notes? So next, we're adding previously approved wording for teleconsulting, telehealth, telemedicine, and teletriage, which were previously approved by the board at their July 22nd, 23rd, 2021 meeting. With the removal of the word representative and adding the word agent at the end of subsection H under telehealth, which is at the top of page 6. Any discussion on that since it has already been approved by the board? discussion from the public? No, we did not.
Oh, we did not, no. Okay, yeah, sorry, I completely forgot about that as well. So if we want to go back to the definition part and see if we can open up, moderator, please, for public comment on our definition portion before we move to this discussion.
All right, this is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on the definition portion, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And it does look like I have a couple individuals with their hand raised. So I'll go in the order that they show on my screen. First, we have Brittany Benessy. And Brittany, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Members of the committee, Brittany Benessy on behalf of the American Society for the Prevention of Speaking today with regard to the proposal's definition of telemedicine and the existing VCPR requirements. Telemedicine benefits a wide range of people and pets, including anxious pets, large animals, and those living in remote and establishing in statute the regulations that keep vets from practicing veterinary medicine or prescribing medication unless they have recently examined the animal, a difficult and often unnecessary obstacle for many pet owners, especially at a time when there is a significant shortage, would stall one of the most promising tools in the Access to Care toolkit. As you know, access to care is a hardship for many pet owners. In 2020, the chief economist for the AVMA estimated that over 50 million pets, approximately 1/3, do not see a vet at least once a year. A national study also showed that 40% of low-income owners who rehomed their pets reported that access to affordable vet care would have helped them keep their pet. During the tightest restrictions of the COVID-19 pandemic, telemedicine was essential to ensuring pets access to healthcare. The use of veterinary telehealth showed its potential to significantly improve animal welfare across the geographic and economic spectrums. The proposed legislation would put into law stringent limitations on the use of telemedicine and reduce veterinary access for all clients who have difficulty, whether due to age or disability, animal behavior, or geographic location, in making it to an in-person physical examination to establish a VCPR. Putting energy and resources toward a law that will curtail promising tools at a time when we should be exploring every pathway to improving access to care will further hinder veterinary access for Californians. I respectfully ask that you reconsider this proposed legislation in its current form and refrain from recommending it to the board. Thank you so much.
And to clarify for public comment, right now we're just on the definitions themselves. And so if the members of the public have general concerns about the entire legislation, if you hold on until after when we're discussing the rest of the proposal as well.
All right, this is a moderator. We'll move on to Dr. Jenny Godken. And Dr. Godken, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
I did have some concerns, but I don't know if the time has passed because the Q&A wasn't open. I was going all the way back to the definition of herd. So I will go ahead and defer that in the concern of moving the meeting along.
Dr. Godken, we're actually taking public comment on the definition. So if you have a concern about herd, then we welcome that.
And it's more of a clarification from enforcement standpoint, as well as just protecting both members of the public and licensees. So the way I read it, and again, I know this is in context of prophylactic care, which could be vaccinations as well. 2 species in a same geographic household could be 2 cats in a household. So potentially an exam may not have to be done on a second cat in a carrier that comes in for prophylactic care, such as a distemper vaccination. I'm just trying to figure out if what exceptions might be made that might, I would say, butt heads with unwritten standard of care in the veterinary community. So I just want to clarify, as well as the veterinarian possesses sufficient knowledge. I don't want this to turn into a thing where members of the public are almost saying, well, you don't have to interpret this as, why does a veterinarian have to do an exam on my second cat? Sort of thing. I know, there's members of the public that come to enforcement and ask, my veterinarian won't refill heartworm, prescriptions without an exam. And I just want to make sure that there's nothing in here that is actually going to do the opposite and almost have certain practitioners, and I am specifically thinking of small animal in this case, feel cornered into over interpreting this for the sake of a client. I guess point to the veterinarian possesses sufficient knowledge. I guess the veterinarian can say, I don't feel like I possess sufficient knowledge of your other cat to go ahead and vaccinate without, establishing a VCPR. So again, I'm just clarifying that the definition of herd can just be 2 cats in a household as well. And prophylactics can mean vaccination.
All right, this is the moderator. We'll move on to our next individual. An individual signed in as Paul McLennan. And Paul, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, panelists. This is Dr. Paul McClellan, an equine veterinarian of 40 years. And I wanted to speak about this unique aspect of veterinary medicine in the equine world that has to do with the fact that for a large majority of horses, it is a business, and there are people in the middle between owners and veterinarians. And as you're trying to work out this language, it is true that very often the client is not the owner. It is very often that the client may not even be present and that a subordinate is presenting the animal. There are numerous business variations to this theme that need to be considered. The other comment is that is for the protection of the consumer, and this is an important part, but it should not be exclusive of protection of the horse. That thought that the consumer knows what's best for the horse or knows anything more important about the horse's health is a naive thought. The reason that so many of these horses are put with trainers is that in order to care for them properly, for the use that people are using, the various uses, the trainer has much more expertise and knowledge of the care of the horse. Most of the time, in my experience through many years, when people say, I didn't know my trainer was doing this, I would tell you the majority of the time is because they simply don't want to pay the bill. And because these contracts are all verbal and assumed, and that is historically how it is operated. We need the paperwork trail of signatures to say, yes, I did authorize this person to make decisions about my horse. We have clients who do that, and they put it in writing for us, and they may make exclusions except for this situation or that situation. But those are business contracts that get in the middle of what we're trying to accomplish here
15
in deciding
seconds.
who the client is. So I would just leave you with those few thoughts as you wrestle with this definition. Thank you.
Thank you.
right, this is the moderator. Our next individual who has requested public comment, Barbara Schmitz. And Barbara, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Good morning. I'm going to reintroduce myself. This is Barbara Schmitz. I'm here on behalf of the San Francisco SPCA. Our organization is 155 years old. We obviously are a sheltering organization, but we do have a significant percentage of staff who also are veterinary staff that care and treat for our shelter animals, as well as providing clinics to help members of the community with their animals as well. Like other shelters and other communities across the state, we are impacted by a shortage of veterinary professionals. We're navigating through it as best we can. The shortage is at a crisis level and it is worsening. The impacts on shelters across the state are significant. The impacts on community members across the state are significant. I'll just use a couple of quick illustrations. The first is that we have been working for several years with partnering organizations, shelters, in what I think of as the veterinary desert in California. Those shelters have significant needs. We take a van down to those shelters on a weekly basis and ask them what they need. And invariably, they fill our van with dogs and other animals that they do not have space for. We bring them back to our shelter. We provide any behavioral needs, veterinary care, spay, neuter, and we adopt out those animals. You would think that having done this for a very long period of time, that those shelters would now be in great condition. They are not. They are still bursting at the seams, and it traces back to a shortage of vet access. Last year, we transported 2,500 animals in this manner. We're happy to do that. We're happy to work with our partners, but we need bigger solutions. And so when I look at the telemedicine provisions in this bill proposal, I just want to emphasize that this is taking us in the wrong direction. Telemedicine is one of several tools that we should be using to help the people in our state who are hurting, to help the animals in our state who are hurting, and to help the veterinarians in our state who are hurting. I'm a little distressed also because it feels like until this point, there really has been no meaningful input and stakeholder input on the telemedicine provisions. It appears that this bill package already has been pitched to lawmakers. And so I do wonder what the meaning is of our ability to provide input now. My request is to put the telemedicine piece on hold. It is the wrong
15
direction right
seconds.
now. Thank you. It's the wrong direction right now. I would ask that you focus on the public need that is out there and please help find solutions instead of erecting barriers in this way. Thank you.
Thank you.
All right, this is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, thank you. And I think Jessica has a few comments for us.
Yeah, just to clarify, all of the provisions in this legislative proposal related to telemedicine and the telehealth definitions and those provisions were already approved through the board last year. They went through the MDC and then the board and provided ample opportunity for comment. So these are not additional related to the telemedicine and the definitions of teleconsultation and the 4 definitions in G, H, I, and J. Those are all provisions that the board has already heard and adopted. These are not what the equine subcommittee is proposing today. They're just part of the package. So just for all transparency, the board, the MDC and the board has reviewed these multiple times and provided multiple public comment opportunities.
The meeting memo actually says that the board reviewed and approved it July 22 through 23, 2021. So it was a year and a half ago with multiple opportunities for public comment. And I would point out that the telemedicine provisions actually are trying to expand the use of telehealth beyond what is currently allowed through the Regulations and Practice Act. So perhaps the groups who are raising concerns could provide some more specific concerns at some point with this legislative proposal, keeping in mind that in order to administer, prescribe, or dispense a medication requires an examination of the animal that currently cannot be done under federal law through telemedicine. So this proposal complies with federal law while expanding the use of telehealth avenues.
Okay, thank you. Back to the comment about the two cat situation. It is not, when we write these regulations, it is not superseding the authority of the veterinarian. The veterinarian decides, it's their license. They decide whether there has been a proper examination for the herd to do whatever they're doing, or for two individual animals. So that is who sets the criteria, not the public. I hope that addresses the concern. Okay. Yeah.
I think we were talking about potentially taking a 10-minute break after these comments, and then we will have lunch at 12:30. So if we break now until 11:30, we can come back and move on, if that's okay with everyone. 11:30 now, so we will get back to work here. It looks like we've now taken discussion up to section 4826.1. Dr. Sullivan?
Okay, so some of this is just bringing forward Regs 2 statute to streamline things. So those sections we hopefully won't need a detailed discussion. So 4826.01 is dealing with the VCPR, and largely is copied from 2032.1 with the following revisions. And now we're on page 6. So subsection A, the proposal would maintain the VCPR requirement under federal law and existing regs 2032.1 for a veterinarian to establish a VCPR before prescribing, dispensing, or administering a drug, medicine, application, or treatment to an animal. Proposed subsection A3 would include the informed client consent provision approved by the board on January 30th, 2020. So we're moving things around, so there's no substantive change other than the client's consent, which was approved by the board. Subsection B, I'm going to go through a couple of these and then we'll stop and go back through them. Subsection B would maintain the provisions of Regs 2032.1, subsection B2, and restructure the provisions to clarify the animal knowledge can be satisfied by recently examining the animal, or if the animal is a member of the herd, being treated prophylactically to prevent diseases, or treated as a group for routine husbandry procedures by making medically appropriate and timely visits to the premises on which the herd is kept. And then I'm going to the next one, and then we'll go back and discuss. Section C, the proposal would establish the client's ability to authorize an agent to act on the client's behalf to establish the VCPR with the veterinarian. This provision is intended to resolve CVMA's concern that the owner of the animal may have delegated animal treatment authority to a trainer or barn manager. So let's go back and discuss which would be 4826.01A, and then subsections 1, 2, and 3. Committee comments on this wording? Comments from the public in the room? So you can ask the moderator to open it up.
Seeing none in the room, moderator, can you please open this for public comment online?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please.
Okay, and I just want to reiterate, we're moving most of this from regs to statute and reorganizing it so it's a little bit more coherent and kind of all in one section. So a lot of this is existing regs. So we'll go to subsection D. The proposal would maintain the existing VCPR exemption in the absence of a client communication. This is the same as in regs 2032.15, subsection B2. And now we're on pages of your packet, pages 6 and 7. Subsection E, the proposal would maintain the existing prohibition on establishing VCPR solely by telephone or electronic means, which is in regs 2032.1, subsection E. Subsection F, the proposal would maintain the existing VCPR exemption for wild animals and unknown owners, which is 2032.1, subsection A, and include an exemption for rabies vaccinations approved by the board on July 20th, 2022. And subsection G, the proposal would maintain the existing VCPR exemption in the absence of the original prescribing veterinarian, which is covered now in regs 2032.25. And covers subsection 1, 2, A, B, C, and D. Any comments from the committee? Okay. You can turn it over to the public.
Are there any public comments from those in the room? So we are talking about up through letter D then on page 8. Comments in the room. Moderator, can we open up public comment for this section, please?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please.
Okay. The next section is proposed BMP section 4826.6, which relates to telemedicine. The legislative proposal includes the previously board-approved telemedicine provisions. The subcommittee also proposes a technical amendment to subdivision B2 to remove and replace client's representative with the word agent to conform with the new use of agent in the legislative proposal. This is on page 8. I would also say that this is the section that allows telehealth, kind of clarifies it more clearly that in telehealth, a veterinarian can discuss up to and including a presumptive diagnosis with the client without first seeing the animal. And under telehealth, that also provides information to the client in the general terms as to what they can do with that information. However, if there is a prescription needed or a treatment that is needed, that would trigger the in-person exam or knowledge of by visiting the premises in a herd situation. Any comment by committee members?
Any public comment in the room for this section 4826.6? Seeing none, moderator, can we please open the online WebEx for public comment?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And it does look like we have a request for comment from Paul McLennan. And Paul, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Thank you again, Board. These matters are not what I usually spend my time doing, so I apologize in advance that I may be a little unprepared for some of this, but recent events in the equine world have caused me to want to and need to feel like I need to take more interest. There are many times that veterinarians will render opinions on a horse without ever seeing the horse, based on received materials, x-rays and whatnot. I just want to make sure that that subset of activities is covered in what is termed telemedicine, because we are rendering decisions and judgments on horses, particularly in buying and selling and other things, because in large part, of course, the digital world has made video clips of horses available and x-rays and all of these things by digital means so easy to access. So if this is being considered as still appropriate, I think that would be very important to me in as you're talking about telemedicine type of work. Thank you.
Thank you.
All right, this is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please.
Thank you, Dr. McClellan. I am glad you're here and encourage you to participate at every one of our meetings because we need that input. There's two different areas, and I'll have staff correct me if I'm wrong. Under one condition, your work could fall under teleconsulting. However, that would be providing information to the veterinarian who has the VCPR. The second area that it could fall under would be if you have a working relationship with that stable or with that owner, and have visited the premises and have an existing VCPR through that means, I would assume there could be some direct communication there, but I will leave that to our staff to address that more clearly. But the teleconsulting is veterinarian to veterinarian, and you don't need a VCPR for that if you're the specialist that is commenting to the veterinarian with the VCPR.
Looks like Dr. Bradbury has a comment as well.
I guess I was, maybe I'm misunderstanding this, but I was reading the telehealth as sort of covering the situation that Dr. McClellan was talking about, because he was basically being asked for his opinion on whether or not to, like, buy a horse, or it sounds like discuss the general health, but he's not being asked to prescribe medication. So, and it's a person and horse he hasn't seen.
He may be diagnosing, though, with x-rays.
Yeah, you just can't prescribe.
Okay.
So I think that that's covered here, and I agree. I would like to just chime in on the, please, we encourage you to continue participating, because it is these sorts of scenarios that help us to know that, you know, which way we're going, and make sure we're thinking of all of these different situations that some of us may not have experienced. So thank you for your participation.
And to clarify for that situation, is we're talking about 4826.6 B1, where the diagnosis and the preliminary diagnosis for the general health of the animal patient using virtual examination is okay. It's the trigger of the providing treatment. That's where you need to have the hands-on physical exam first.
Okay, any other comments? So then that leads us, if I'm not mistaken, to section 4829.1, prescription duration. The proposal would maintain the existing one-year prescription limitation and definition of drug and regulation, which corresponds to 2032.1 subsection subsection C and D. I think we're doing this in this section just to firm it up that we have the statutory enforceability of the previous regs. Any comments from the committee? Public?
Any public comments on this section here in the room? Seeing none, moderator, can we ask for public comment on section 4829.1 from the online public?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And it looks like a request from Barbara Schmitz. And Barbara, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Thank you. This is Barbara Schmitz from the San Francisco SPCA again. I just wanted to sort of bookend my comments at the beginning of the telemedicine sections that you all are here, and let you know that those concerns remain. I wanted to make sure to refresh my comments substantively and also procedurally with this particular part of the package. So again, just making sure that that was clear and letting you know that we do have concerns.
Thank you.
All right, this is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please.
Okay. The next item is section 4875.1, investigation and prosecution priority. Since the VCPR regulatory provisions would be moved to statute, all reference to the VCPR regulation, which would be repealed in a subsequent rulemaking, would need to reflect the new VCPR statute. Accordingly, BCP section 4875.1 subdivision A7 would be updated to remove and replace 2032.1 of the California Code of Regulations with 4826.01 of would be the proposed new BP&C section for the VCPR. Any discussion from the committee?
None. Is there any public comment from those in the room on this final section of this agenda item? Okay, seeing none, moderator, can we please open this for public comment for those on WebEx for the final section 4875.1, please?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, thank you.
The last item on the memorandum deals with cleanup. As discussed above, the existing VCPR regulations as revised are proposed to codify in statute in the subcommittee's legislative proposal. If the VCPR legislative proposal is enacted, the subcommittee would recommend the VCPR regulations, sections 2032.1, 2032.15, 2032.25 be repealed. In addition, the committee would recommend a conforming amendment to section 2038.5 to remove and replace citations to sections 2032.1 and 2032.15 with the new VCPR statutory sections 4826.01. And the subcommittee will recommend this rulemaking to be submitted as a Section 100 rulemaking, as it would merely reflect the new statutes making the existing regulations redundant and outdated. Any comments from the committee? Okay.
Do we have any comments on this from the public in the room? Seeing none, can we please open this for any further public comment from those on WebEx?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, thank you.
And I would suggest that we hold this over to this afternoon to see if we can better address the definition of client, and because everything else I think looks pretty good.
Okay. We have 4B do that, yeah? No. Okay, then we will hold this till this afternoon, seeing if we can do some wordsmithing on the word client, and we will then move on to the next part of this agenda item, which will be 4B, the recommendation to the Board on California Horse Racing Regulatory Proposal, and that will be presented by Marie.
Okay, a little bit of background on this. During the spring of 2022, the California Horse Racing Board, the CVMA, and the UC Davis School of Veterinary Medicine, as well as several equine veterinarians, raised concerns to the VMB about how the Practice Act was being applied to racetrack veterinarians and the equine veterinary community. A subcommittee was appointed and subsequently met with representatives from CHRB, CVMA, and UC Davis School of Veterinary Medicine. With respect to racetrack veterinarians, concerns centered around the interpretation of Title IV, Section 1867, subsection B, involving the use of substances or medications that have not been approved by the FDA. The board interprets this regulation as written. However, CHRB disagrees and sent out an advisory to racetrack veterinarians stating that compounded medications are not FDA approved, but lawfully prescribed compounded medications manufactured according to federal and state guidelines do not violate the regulation. CHRB and the subcommittee agreed that amendments to Title 14, Section 1867 would be necessary to allow racetrack veterinarians to administer or dispense non-FDA approved medications to equine patients. In November of 2022, CHRB staff sent to the subcommittee proposed amendments to Title 14, Section 1867, subsection B. CHRB is planning to amend the regulation as an emergency regulation. The subcommittee strongly agrees with that approach. The subcommittee reviewed CHRB's regulatory proposal and recommended several changes and raised concerns. CHRB accepted 2 of the subcommittee's recommendations. The final regulatory proposal did not include the subcommittee's recommendation to define the difference between compounding office stock and prescribing a compounded preparation for an individual horse. According to the FDA's GFI 256, which will be enforced starting in April of 2023, there is a restricted list of compounded preparations, there's 5 as of right now, that a veterinarian can have as office stock. Since the regulatory proposal addresses drug compounding issues for equine medicine, the subcommittee felt that this would be a great opportunity to get this information out to equine veterinarians. At CHRB's November 22nd meeting, agenda item 20 addressed the proposed regulatory amendments to Section 1867, subsection B. And in the meeting materials for this item under the heading Issue, it stated the following. The California Veterinary Medical Board provided feedback on the proposed amendments, and that feedback was considered in the proposal before the board. Given the present severely negative impact on CHRB licensed veterinarians due to this incorrect interpretation by the Veterinary Medical Board, these regulatory changes, if approved by the board, will be pursued in emergency fashion. With respect to the statement in the CHRB meeting materials regarding the purported incorrect interpretation, the subcommittee notes that during the subcommittee's September 28th meeting with CHRB staff, their attorney did not argue that the board's interpretation was wrong. In fact, staff conceded that the plain language of Section 1867, subsection B, does not provide for any drug compounding exemption from the regulation's prohibition on the possession and or use at a CHRB regulated facility of any drug, substance, or medication that has not been approved by the FDA for use in the U.S. To correct the record and advise CHRB of additional requested amendments, the subcommittee decided to make a public comment at CHRB's November 22nd meeting. Based on the subcommittee's belief that public comments could be provided by teleconference during the meeting, Dr. Sullivan was prepared to provide the subcommittee's comments virtually in connection with agenda item 20. Unfortunately, that option was not available at the time of the meeting. Rather, they announced that during the meeting, the public had to be present, sign in, and state that the individual wanted to comment on an agenda item, indicate the agenda item number, and public comments were limited to 2 minutes. As such, the subcommittee was unable to testify because neither member of the subcommittee was in Sacramento on that day. On December 20th, 2022, the subcommittee sent a letter to the CHRB executive director describing the comments the subcommittee had intended to provide at the November 22nd meeting. CHRB staff has concerns with board regulations, and we discussed some of the definitions in the last section that we proposed to try to help with some of those concerns. So currently, the subcommittee's recommendations, in addition to addressing those concerns we discussed earlier, are for Section 1867 rulemaking. Since the subcommittee was unable to testify at the November 22nd meeting, the subcommittee recommends that the board submit the attached letter to provide comments to CHRB on its rulemaking during the 45-day public comment period. To date, neither the emergency rulemaking nor the regular rulemaking have been posted to the website. And as discussed above, the subcommittee is proposing the legislative changes or amendments under the agenda item we discussed earlier.
Sure, I would like to open this up for discussion then for members of the committee. No comments? How about public comments from those in the room? Okay, seeing none, moderator, can we please open this up for online public comments regarding this section?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And it looks like we have a request from Nancy Eierlich. And Nancy, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. And this is the moderator. Nancy, you'll want to click the unmute me button when the prompt appears on your device.
Did that work?
Yep, you're unmuted now.
Okay, I just have a quick question about compounding under, let's see, amend section title, CCR Title 4, Section 1867. B, it says a drug compound is compounded by a California licensed veterinarian or a California licensed pharmacy. RVTs are allowed to compound. So is there some reason why they were left out of this? That's my question.
All right, this is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please. Okay, do we have any other comments from anyone on the committee, or anyone like to make a motion?
Just to comment to Nancy, we were a bit cautious on what we were saying since it's their regs and not ours, but I do not think that it preempts, what they're doing preempts a veterinary technician, a registered veterinary technician from compounding in an equine setting. So I think the rules that we have, the regs that we have on this are fine.
So I'll make a motion. Let me get to it here. To recommend to the board to send a letter to CHRB providing comments on the CCR Title 4, Section 1867 rulemaking during the 45-day comment period on the rulemaking.
Second.
Okay, we have a motion and a second. Is there any comments from the committee? Any public comment on the motion from those in the room? Okay, moderator, can we please open this up for online public comment on the motion?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. Okay, can we please have a vote on this motion?
Mr. Phelps?
Yes.
Dr. Sullivan?
Yes.
Dr. Bradbury?
Yes.
Dr. Lazarev? Dr. Lazarev?
Sorry, yes. Didn't unmute myself.
Ms. Laredo?
Yes.
Dr. Sequoia?
Yes.
Ms. Osry?
Yes.
Motion carries.
Thank you. Since we are holding off the rest of item number 4 till this afternoon, that would take us to agenda item 5, which is update, discussion, and potential recommendation for rulemaking on the VCPR, animal health care tasks, and tasks for RVTs. And Dr. Sullivan will be presenting on this.
During the public comment portion of the Access to Veterinary Care Task Force report at the October 2022 meeting, of the Veterinary Medical Board, the CVMA reported on the progress made by their Access to Care Task Force, of which Dr. Nolan is a member. CVMA's Access to Care Task Force, along with its RVT committee, conducted an analysis of the RVT profession and found that there may be an opportunity to increase access for low-income individuals by increasing the scope of what RVTs can do under the direct supervision of a veterinarian in an animal hospital setting. After the October board meeting, CVMA sent a letter and regulatory proposal to the board's executive officer, which was forwarded to all MDC members in preparation for this meeting today. To streamline the process, MDC leadership decided to work with board staff and legal counsel to evaluate the proposal prior to the January meeting and be ready with recommendations to the MDC if approved, and then to the board. Over the last few months, MDC leadership met multiple times with board staff, legal counsel, regulations legal counsel, and CVMA to discuss what could be done through regulations to safely increase access to veterinary care while maintaining adequate consumer and patient protection. Specifically, MDC leadership focused on how an RVT could safely perform vaccinations and parasite control under the direct supervision of veterinarian without requiring a veterinarian to physically examine each patient prior to the RVT's rendering services. These Zoom meetings included a recent meeting in which Dr. Miller took time away from his vacation in Hawaii to participate with the subcommittee, staff legal counsel, and regulatory counsel, above and beyond. You have a copy of the letter from CVMA and the rough draft of the proposal, so let's jump right into the regulatory proposal. This is the first time that we have done regulatory reviews with regulatory legal counsel prior to going to the MDC or the board, with the idea of streamlining the process, getting the legal bugs out of it before it goes further. Today's process may be slower because of that, but we want to make sure that we have the proper wordsmithing. Sometimes the legalese can get in the way, so we are going to take our time with doing this. After the work on the word client, I don't know how we're going to do this, but so let's start with page 8. This proposal creates a way for a veterinarian to establish a VCPR for the purpose of permitting an RVT to administer preventative or prophylactic vaccinations or medications for the control or eradication of apparent or anticipated internal or external parasites if certain conditions are met. Subsection A, this amendment for the rabies vaccination was approved by the board during the July 2022 meeting. So I'm going to go through a couple of sections, and then we'll, go back and review them as one. In Section B, this amendment provides an exemption to a veterinarian establishing a VCPR under circumstances set forth in the new subsection E. In addition, subsection B3 reflects amendments approved by the board during the January 2020 board meeting regarding informed consent of the client. So let's handle that, and then we'll go into the big section on E.
Okay, are there any comments from any members of the committee on this first part? Okay, seeing none, we will open this for public comment for those in the room. Moderator, can we please open this to public comments for those online?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And I'll go ahead and pause a moment to allow the public time to access these features and submit their requests. All right. And seeing none, would you like me to close the Q&A panel?
Yes, please.
Okay, subsection E, this amendment specifies that a veterinarian can establish a VCPR for the purpose of permitting an RVT to administer vaccines, medications, as long as the following conditions are met. So I am going to throw out a issue that I have with the word administer, because we do use it a couple of times. And my question is, does administer include sending medications for parasite control home with a client that may last for 6 months? Now in E5, we are addressing it, but my concern is further down towards, actually on page 11, we do have a definition of administer, which I think contradicts somewhat of what we're doing. So, Tara, can you address this for me, please?
Yeah, administer only means delivery, immediate delivery. I mean, I think administer, the definition of that under 2034 subsection H means the direct application of a drug or device to the body of an animal by injection, inhalation, ingestion, or other means. If the client takes home medication, that's dispensed. So, and an RVT is not authorized to dispense under this proposal. So they can only administer directly to the animal.
So in this case, well, then let's go through this bit by bit, and we should be able to address that as we go through it, correct?
Sure, but I will maybe hopefully cut to the chase. That provision under subsection E that notates prescribing or dispensing is about reminding everyone that the veterinarian has to prescribe all treatments, medications for use on the animal, administered at that time, or dispensed. So prior to the RVT administering, the veterinarian has to prescribe the medication. And also, prior to the client walking out the door with medication that's dispensed, the veterinarian has to prescribe.
Okay. So let's cover a couple of these, and then we'll discuss them in more detail and kind of do it, a couple sections at a time. So the first subsection 1, the vaccine and, vaccine medications are administered in a hospital setting under the direct supervision of a licensed veterinarian. So that's subsection E1. The second is the RVT examines the animal patient and administers the vaccines, medications according to written protocol and procedures established by the supervisor, which is the veterinarian that has the oversight. Those protocols and procedures are required to include, at a minimum, patient history of data is collected to ensure administration of the vaccine and medication is possible. That's subsection E2, A, and B. Information that would preclude a patient from receiving the vaccines and medications and the criteria that would disqualify the patient, subsections E2, C, and D. And vaccination protocols and preventative procedures to ensure proper handling and administration of vaccines and medications in accordance with manufacturer's label recommendations and what to do in the event of an adverse reaction or other emergency, in that subsection E2, E and F, and then documentation requirements, which is subsection E2 and G. So there's a lot here, but it's in a pretty good orderly fashion. So let's open it up for any comments by the committee.
I don't see any at this time. How about public comment from those in the room on this first section of this agenda? Okay, can we please open this to online comments for public comment on this first part of this item, please?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And I'll go ahead and pause a moment to allow the public time to access these features and submit their requests. Great, now it looks like we do have a request for a comment from individual identified as Anita Levy Hudson. And Anita, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
I just wanted to say that I am really excited by this as an option for clients and for patients. I can see the huge benefit to this. The only thing that comes to my mind right now is a question about, well, I guess, well, I initially had a question about any kind of like heartworm test before administration, but that I can see now as I was waiting to be unmuted or have the opportunity to unmute myself, I can see that that is also kind of covered in here. So I guess I will just close with a comment that this is an exciting proposal. I really am interested to see how this goes. Thank you so much.
Thank you, Anita.
All right, this is the moderator. It appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please, and we will continue on to the next part.
Okay, the next section, the supervisor and the RVT sign and date a statement indicating the following. The supervisor assumes responsibility for all acts of the RVT related to examining the animal patient and administering the vaccine/medications. This is covered in subsection E3A. The RVT is only authorized to act as the agent of the supervisor to establish the VCPR relationship, veterinary client-patient relationship, for purposes of administering the vaccines/medications when acting in compliance with the protocols and procedures, and only until the date the supervisor terminates supervision or authorization for the RVT to act as the agent of the supervisor, which is covered in subsections E3B. Any comments by the committee?
Seeing none, are there any comments from the public in the room on this section? Okay. Can we please open this for online comment to the public?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And it looks like we have requests for comment from Nancy Eierlich. And Nancy, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Okay, this document that the RVT and the veterinarian have to sign, is it for each individual office call, or is it a one-time deal for the veterinarian on that particular RVT until the veterinarian withdraws it?
I'll take care of that afterwards.
Thank you, Nancy. I think that'll be a little bit further explained here as we continue on.
All right, this is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please.
Yes, the contract is between it can be between multiple veterinarians and the RVT, so that when the RVT is providing these services, that there is a veterinarian that is their supervisor. And that contract begins on day one when they sign the contract and ends when that contract is terminated, and the medical records need to be kept for 3 years after that, or the contract records need to be kept for 3 years after that. So it's one contract covering the veterinarians on the premises with the RVT, with each RVT, and therefore the responsibilities of supervising that RVT.
I have a note on page 9. Section 2032.1, subsection E, paragraph 3, subparagraph B. It says the RVT is only authorized to act as the agent of the supervisor to establish the VCPR. So I'm wondering if perhaps that may be where Ms. Ehrlich is raising concerns. So, you know, our intent was really that this agreement between the supervisor and the RVT be broader than just one animal, and cover all VCPRs established pursuant to this provision. I'm thinking that perhaps we could change the at the end of that first line to A for a little bit more clarification that it's not a single VCPR, but it's establishing a VCPR.
Could we change the to all and then change relationship to relationship?
What's that?
Or even just say establish veterinary client-patient relationships.
And make it plural?
Okay. All right, so we're talking about striking the at the end of the first line of subparagraph B, paragraph 3, and on the second line after relationship, inserting S. Does your regulatory counsel have any concerns with this change?
I don't. I think that's an elegant solution.
Thank you. I see, Dr. Sequoia, you have your hand raised for a comment.
Yes, I do. Thank you. This is Dr. Sequoia, and my comment is, will that change that was just suggested cover veterinary hospitals if there's a temporary veterinarian filling in or not? Thank you.
They would have to have a separate authority.
Just to add to that, it's you know, establishing that the temporary veterinarian is specifically authorizing this RVT to act as their agent. So they would need to have that agreement with the RVT because the temporary veterinarian is otherwise acting outside the scope of the typical VCPR. So that temporary veterinarian could only be protected when using the RVT as the agent for the VCPR if this agreement was in place with that temporary veterinarian.
Does the committee perceive that to be a problem if that form has to be filled out every time a temporary veterinarian substitutes in or not?
My thought on it is, personally, that they can choose to have that relationship with that RVT or choose to not have those kind of appointments or procedures taking place because it is their license status on the line. And I think that should fall to that individual veterinarian to make that decision. And, you know, they could have some sort of a form letter, but I think that's the best way to protect that veterinarian as well as the staff members.
Well put.
Thank you.
Okay, the next item, this is page 9 and 10. Prior to examining or administering the vaccines/medications, the RVT discloses that the RVT is acting as the agent of the supervisor for purposes of administering to the vaccines and medications, and provides the supervisor's name and license number to the client. The RVT would then be required to obtain client authorization to proceed and document such authorization in the medical records. This is E4. Any committee discussion?
Don't see committee discussion, but it looks like we have a member of the public, Dr. Miller, here for comment.
Forgive me if my approach is premature. Do you want me to wait?
Nope.
So the California Veterinary Medical Association met this past weekend here in Sacramento with our leadership. So we had our House of Delegates and our board meeting. Our House of Delegates is composed of approximately 65 veterinarians and RVTs from around the state. I'm very pleased to report that they had overwhelming support for this measure, and actually went on record with a motion to voice their support, even though we really didn't need it. But the one comment that was made was the question regarding 2032.1 E3, strike that, E4, regarding the disclosure of the supervisor's name and license number. The veterinarian's comment was, is it really necessary to disclose the license number of the veterinarian to the consumer? Could it just be stating that, you know, I'm an RVT, I'm acting on behalf of Dr. Sullivan today, or Dr. Bradbury? Would that be sufficient? Because the license number is not something that people might know or memorize. It's a 5-digit number, and that could be kind of burdensome and cumbersome and probably not very useful to the client, especially since the veterinarian's license is prominently posted just outside the exam room in the lobby. So that was a comment that we had received. Thank you.
I was assuming that posting the license, which is required and includes the number, would satisfy this.
Yeah, I think the word provides is the, you know, how we define provide potentially, or disclose.
Yeah, I think that if they're providing something, they're delivering. It's not just, I mean, perhaps the information being delivered is the name and license number of my supervising veterinarian is posted here. Otherwise, it's an oral or written requirement, so they could just look at their sheet. The veterinarian who's my supervisor is Dr. Joe Smith. This is his license number. I mean, that really shouldn't be that big a deal, but it is consumer protection through disclosure. And also, are all in every veterinary premises is a temporary veterinarian hanging a copy of their license outside of every room so that there's easy access to the consumer. I think this is the most protective way to do it because the RVT is acting in place of the supervising veterinarian. And it's a small amount of information which could be provided on a card, you know, vaccination card, or instructions following administration of the prophylactic treatment. Yeah, I think it's a delivery of information, not just it's randomly posted somewhere that the consumer is not otherwise aware of.
Then, in your opinion, Tara, this could be done on discharge summary kind of thing, the actual number written there. If the RVT is to say, I'm working on behalf of Dr. Sullivan today, he's my supervising veterinarian, the number will be provided for you, or so you could orally do it or have it written at the end of the appointment?
No. So page 9, paragraph 4, it begins prior to examination of or administration of. The RBT discloses orally or in writing.
Okay.
So, but still, that could be in the form of vaccination instructions, because arguably these are specific appointments for specific treatment. So when the appointment is made, the RBT has an idea of what is going to be administered. That was the whole efficiency purpose of this. So when the client comes in and brings in the animal, prior to examining or administering, the RBT already has a sense of what the appointment's about. They could hand over this written document that has the veterinarian name and license number and, disclose at that time that they're acting as the agent of the supervising veterinarian. And that's about letting the client make their own decisions for the animal, disclosing, okay, I'm going to be examining and I'm administering under my supervisor. Here's his name and number. So it would not be in discharge instructions. It would be in information delivered orally or handed over in writing prior to performing the examination or administration.
Okay. Next item.
Dr. Bradbury, and I have not.
Sorry, I'm used to interrupting people, and I'm trying really hard not to. Trying to be. So I don't really have a problem with the license number being on there. I guess would wonder in this setting how much that's going to add to consumer protection. They can, if they were interested or concerned, look up a licensee online just based on their name. And if this is, I guess I was a little surprised by it. I'm okay with it being there as well. I don't feel that strongly either way, but I don't really see how that's going to change consumer protection that much unless somebody...
I think what it does is that it kind of emphasizes to the client that the RVT is saying, this is the setting in which I'm working. Mm-hmm. It brings it right out up front. It's a requirement. I thought it could be passive, but after listening to these comments, I think it's telling the client up front, I'm working on behalf of this veterinarian, and the client can then say, no, I want to see the veterinarian, rather than afterwards.
Just to the comment about they can look up by name, they can, but oftentimes you have the same last name of doctors, and so they might not know which one was the right one.
The next sentence under that paragraph is that after such disclosure, then the client has to consent.
Right. Grant Miller, CVMA, and that's where my comment will stem from, is that in looking at it again, I do see most veterinary practices will probably tend towards written authorization on something like this because they don't want to have to do a lot of the dialogue. They would rather have a form to say, here's the, I'm an agent of this veterinarian, here's their information, we'd like you to just sign our initial here to acknowledge your consent. So that actually seems pretty easy. The other thing is that if the veterinarian is doing their written protocol properly, part of that written protocol should be the inclusion of this disclosure. And in the written protocol that the RVT is following, they can write their license number. So I do see that there could be a pretty reasonable implementation of the license number, and it makes sense. I think when people say people's names, they say, well, this is Dr. Bradbury. How somebody spells your name audibly, the number is definitive. So on second thought, what I'm conveying the thoughts of our leadership, but on second thought, it does make sense to have a number there because that's definitive. 15546 can't be really misinterpreted versus a name can be misspelled or people maybe didn't hear it correctly, so it does make sense. I think also, I'm pretty sure 90% of practices are going to do a written authorization for this, which the CVMA could assist with a sample form.
Thank you.
I'd just like to confirm the license number because, as you all know, this is what I deal with all the time, and names are really funny. There's cultures where they use the first name or the last name, or they change the first name, and there would be a name that somebody goes by all the time that they might write down, and, you know, we struggle to find those people on the website. So I really would recommend that you do add the license number to avoid having to have complaints to the board that say something to the effect that, you know, my cat had a vaccine reaction and I was seen by this RVT and the vet was Dr. So-and-so and you can't even figure out who the vet is. So I think the number is important.
Thank you. I believe we will need to open this to public comment online for this section. Moderator, please.
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. I'll pause a moment to allow the public time to access these features and submit their requests. It looks like we have a couple requests for comment. Give me one moment while I pull up my timer, and we'll go in the order that comments were received. So first we have Nancy Ehrlich. Nancy, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
I find this requiring of the reporting the doctor's, the supervisor's name and number to be very, very odd. Veterinarians walk into exam rooms every day and say, "Hi, I'm Dr. Jones." They don't give their license number. So why do we have to give the license number when we are giving a vaccination under the supervision of a veterinarian? We do all kinds of things under the supervision of a veterinarian. We go out and we take the animal from the exam room and bring it back to the treatment room, and the doctor back there, do we come back and say, "Dr. Jones, license number 772, just authorize this," or whatever? I think this is absolutely ridiculous. Veterinarians don't walk into the room saying, "This is my license number." Why does the RVT need to do this? If the client has a problem, they can go find the veterinarian's license number on the wall. They can look it up online, and it's not that difficult. When you look somebody up online, it gives you their address as well as their name, so you know if it's the veterinarian working in your community. I just think this is completely absurd, and clients are not going to be paying any attention. It says you can do this orally. Are people going to be writing down the doctor's name and number while the RVT is telling them this? This really makes no sense. I'm sorry.
All right, this is the moderator. We will move on to our next individual who has requested public comment. Individual identified as Anita Levy-Hudson. And Anita, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Thank you. My comment was really a question, and it's kind of in the similar direction that Nancy was going, which is when I was thinking about why this would be required, my impression is that it's to give some sort of comfort to the client that this is an actual directive from a credentialed person. And when I think about it that way, I think about, wouldn't it be more beneficial for the RVT to be providing their license number? Since when you walk into a practice, your DVM, you know is a DVM, but the client doesn't know the difference generally between an assistant and an RVT. So I guess my question is, if we're looking to instill confidence in the consumer and protections, should we maybe think about having the RVT license be provided either in addition or instead of?
All right, this is the moderator, and it appears that was our last request for public comment. Would you like me to close the Q&A panel?
Yes, please, Mr. Sullivan.
Yeah, I think we are entering a new phase of tasks for an RVT, which is establishing under certain conditions a VCPR, which by law can only be done by a veterinarian. So we have to have this supervision, and we have to disclose it. So I think it's necessary and important for public protection. I don't think it's cumbersome, and we're not insulting anyone. We're actually trying to expand this area, and I don't know of any place in the country that is doing this. So we're being really cautious.
This is the moderator. I just want to interject real quick. It looks like we do have another request from Nancy Ehrlich to speak. Do you want me to allow her to speak again?
Yeah, let's have Jessica's comment, and then we can open it up. Oh, okay, Nancy. Yes, please open it for Nancy to speak.
Okay, Nancy, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
I just wanted to remind everybody that according to the new regulation, everybody has to wear a name tag with their license number on it starting January 1st. So RVTs who walk in the room will have a name tag with their license number. And if I was upset with what happened in that exam room, I would be wanting to report that RVT, not the doctor who supervised the person who wasn't even in the room when all this happened. So I think you need to take that into account.
Thank you, Nancy. Jessica?
Yeah, so Nancy actually kind of touched on it, but to clarify, we're talking about the new statute that went into effect January 1, but it wasn't actually enforced until, it's not effective until January 1, 2023. It was part of our sunset bill, though, that was effective January 1, 2022. But that is specific to, it doesn't include veterinarians, but to a prior comment about requiring the RVTs provide that information for the RVT would be on that name tag. So they are getting the name, registration type, and registration number. So the RVTs would already have that on their name tag. The veterinarians do not.
I'd just like to add that, providing the name of the RVT is great, but also the consumer needs to know who's responsible for this RVT if the administration is improper or the animal is harmed. While the consumer will have the RVT's information, the consumer should also be provided the information of the veterinarian who's responsible for the RVT. That's really what the requirement is about. And also, I mean, if this is documented like we're discussing here today, it becomes part of the medical record as well. So it'll be easier for the veterinarian and staff to identify, and also the board, who was responsible for the RVT and what happened. So it'll be easier for the consumer to communicate directly with the supervising veterinarian because they'll already have their information. They can complain, which is effective to protect the animals and for future visits. But yeah, I mean, I don't really see any downside here for not disclosing the supervising veterinarian's information.
I think we're going to try to move on through this before breaking for lunch.
Okay, the next section is a supervisor reviews the required documentation prior to prescribing or dispensing vaccines or medications. This is E5 on page 10, subsection E5. Any comments from the committee? This is a section that will allow the client to receive medication going home for the next 6 months for flea control or whatever, or heartworm.
Any public comments for this section from those in the room? Okay, can we please open this up to online comments for this section?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. I'll go ahead and pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. I think we're going to go through.
Okay, subsection F, this amendment requires the supervisor to retain the protocols, procedures, and statement for the duration of the RVT supervision and until 3 years from the date of the termination of the supervisorial relationship with the RVT. I'm just going to keep on going here until we get to the end here. The regs 2034, this is the animal health care task definitions. This amendment adds to the direct supervisor definition so that the RVT can examine the animal as the agent of the veterinarian for the purposes of administering the vaccines/medications in accordance with 2032.1 subsection E under the direct supervision of the supervisor, subsection E2. And the last is the CCR 2036, Animal Health Care Tasks for RVT. This amendment specifies that an RVT can administer the vaccine/medications in accordance with CCR 2032.1 subsection E under the direct supervision of a licensed veterinarian. Any comments from the committee?
I'm sorry, I know I'm hungry, but we kind of breezed over this prescription of dispensing of medication. Sorry, the 5FEG, they kind of blend together here.
Yes.
I think it's 5, page 10.
Yeah.
Second paragraph, prior to
subsection E, 5, page 10.
Yeah, prior to prescribing or dispensing the preventative or prophylactic vaccines. So this is saying that they'll be reviewing the information from the RVT, and the doctor will be dispensing medication without doing a physical exam of their own.
Correct.
Okay.
That's the authorization part. But
Okay.
It's not the RVT doing it. The supervisor has to go over the exam, the records that are created before they can do the prescribing.
Okay.
So now we're talking about subsection F and then sections 2034 and 2036.
Any public comment from those in the room on the rest of this? And if we can please open this up online for public comment.
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And it looks like we have a request for comment from Nancy Eierlich. And Nancy, you'll have 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
I have a question about number 6 on page 12, administer preventative or prophylactic vaccines under RVT job tasks. If by putting it here, does this mean that unregistered assistants cannot do this? Because all these other job tasks are ones that are limited only to RVTs. So that's, well, no, this is the only job task that as far as I understand, unregistered assistants or veterinary assistants can administer vaccinations under the direct supervision of a veterinarian. They just can't do it. They can't create the VCPR. So does this require some sort of statement? besides this.
Well, we'll finish.
Thank you, Nancy.
So, if you look at 2036.5, these are the animal hospital healthcare tasks for permit holders and veterinary assistants, and subsection A prohibits permit holders and VAs from performing any of the functions that RVTs do under 2036, subsections A through C. So we are specifically adding this new VCPR authority under subsection B. So permit holders and VAs cannot perform this, but also it's under B because it will require the direct supervision of the veterinarian.
And I think because it is referring to subsection E of 2032.1, that is clarifying their saying that, that it's not just the administration of vaccines, but it's establishing the VCPR. So that's how that is making that clear.
Yes.
And this is the moderator. It looks like there's no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please.
Are we ready for a motion?
Okay. I think if we have no further discussion, we have a proposed motion on page 4 of this agenda item. If anybody would like to make a motion.
I move to recommend.
Yeah, include, yes.
Amended. Okay, thank you.
I move to recommend the board approve the proposed regulatory changes as amended, direct the executive officer to take all steps necessary to initiate the rulemaking process, authorize the executive director to make any technical or non-substantive changes to the rulemaking package, notice the proposed text for a 45-day comment period, and if no adverse comments are received during the 45-day period and no hearing is requested, adopt the proposed regulatory changes.
I second that.
Thank you. We have a motion and a second. If we can, any comments from the committee? Any comments from the public in the room on this proposed motion? Seeing none, moderator, if we can please open this for public comment online.
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. I'll go ahead and pause a moment to allow the public time to access these features and submit their requests. All right, and it looks like we do have a request for comment from Anita. And Anita, once again, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Thank you. I just have a question about, as I listen and as I think about what we are talking about, and when I think about this from the consumer protection standpoint, I really feel like we should be disclosing the RVT license somewhere in the documentation as well, that from a client protection standpoint, that how are they going to know? Are we going to put some documentation or some other information in the waiting room, or inform them, I guess, of this? Because this is big. This is big and exciting, and it's a good change. But it is significant, and I'm wondering how this might apply in that direction. Thank you.
Thank you, Anita. I think.
Wait till we're done.
Okay, we will wait till the end of public comment to address that.
This is the moderator. It appears there are no further requests for public comment. Would you like me to close the Q&A panel?
Yes, please. So I believe when we're talking about this, as far as this being an RVT only task and the RVTs having to have their license number, that is that our language here in Part 6 prohibits veterinary assistants from being able to do this, to be able to create the VCPR on behalf of the veterinarian. and so only RVTs are able to do this job task, not veterinary assistants. I don't know if that helps.
I think it's as strong as we can make it. I mean, if a practitioner is not abiding by this, I'm sure they're not abiding by a lot of other things. So sooner or later they will get on our radar. But I think we can't spell it out any more clearly, I don't think.
But do you think that the RVT name and registration number should be disclosed in the same way? Yeah, I know. I mean, I think that the client is going to have that information because of the name tags.
Yeah.
I don't think they necessarily need to reiterate that orally, but it could be in writing. It's up to you folks. I'm just, following up on that question.
Yeah. I don't think so. I think the veterinary information is important because they're not in the room. But I think the name tag is going to serve a great purpose here.
If the veterinarian chooses to have the RVT's information passed on to the client, that can be done. But so it's a little less prescriptive to allow the name tag to speak if that's what the doctor would like to have happen. I don't know that it would add any further protection, personally. Dr. Sequoia, sorry, I see your hand up now.
No worries. Thank you. This is Diane Sequoia. I think the name tags are great. I hate to throw a cat into the flock of pigeons, but was there any provision made under ADA for people who have low vision and name tags making sure they have the information?
Yeah, I think we had 18-point font on the name tags for that reason. But otherwise, I don't think there was anything in those provisions for ADA accommodations. Anyone else?
Thank you.
Oh, there we go. I was just thinking, I love the thoughts there behind that. I think we're trying to make this less cumbersome, and it's a huge regulatory package, and you guys have really done so much work on it. It's great. And I think that the consumer could ask for that information specifically if they were even thinking about or worried about the name and license number and couldn't see it. I think they could easily ask for it. So I think that it wouldn't be precluded from their ability to obtain that information, and I'm sure they could still see that it's there if they needed it.
Thank you. I don't see any further comments, so if we can call roll on this motion.
Mr. Felt?
Yes.
Dr. Sullivan?
Yes.
Dr. Bradbury?
Yes.
Dr. Wowschat?
Yes.
Ms. Laredo?
Yes.
Dr. Sequoia?
Yes.
Ms. Esri?
Yes.
Motion carries.
Sounds good. Thank you all very much. I know that went a little bit over, but a lot of good work. If we can take a lunch break now and return at 2 o'clock.